Your colloquy with Justice Barrett makes me wonder whether this case is really the right vehicle to evaluate any of these issues. I mean, how can we say that you meet any definition of the burdens? Justice Barrett went over several different versions of them, when we don't even know how these books are actually being used in the classroom. I mean, this was what I understood the Fourth Circuit's primary holding to be, that the record is threadbare. It contains no information about how any teacher or school employee has actually used any of the books or what any child has been taught in conjunction with their use. And it seems that aspects of your argument are turning on whether the books are just on the shelves or whether students are being taught. And so why wouldn't we wait until we have a record regarding those things before we make any legal pronouncements about what's happening in this case?
Well, two responses, Your Honor. First, this is a preliminary injunction, but if you think about the case, for example, Brown versus hot, sexy, and safe, is that, and I don't even want to describe what happened in that case, but should that kind of graphic sex simulation with a student and a teacher have to happen before you bring a claim?
But I need you to focus on my question. This is a preliminary injunction. I appreciate that. When you seek a preliminary injunction, you actually have to have a factual record that is the basis for the court to make a determination in your favor that some conduct that you're complaining about needs to be enjoined. And what's confusing to me and hard, really hard in this situation is that we have a lot of sincerely held beliefs and concerns and children and principles, and I see all of those things, and so really want to be careful about making the pronouncement that relates to this. I don't understand how we can do it on this record because we can't know. We don't at this moment, based on the record you've provided, know that these books aren't just sitting on the shelves. And you've said that if that's the case, that's not going to be enough.
I disagree, Your Honor. The record is undisputed, and I, again, will refer you to the district court transcript at 63, where counsel
So you're
said
saying the Fourth Circuit is wrong when it says, quote, we don't have any information about how any teacher or school employee has actually used any of the books.
The Court of Appeals did not dispute that some of the books have to be used, and we have all of the teacher's instruction that the board's not disputed.
I understand that, but the Fourth Circuit made a ruling that we don't know, quote, what any child has been taught in conjunction with their use. So are you saying that you do have affidavits and information about teachers in the classroom and what they've taught children of different ages about these books?
Yes, we do. All of our clients have, in their declarations, they describe which books are going to be read to their children.
Were the clients in the classroom?
They were not in the classroom, but they know. And again, we don't have to wait until the injury has happened to get relief. The point of a preliminary injunction is that we can, when the injury is imminent, we can seek relief to stop it from happening before our children's innocence is destroyed.
Let me ask you another series of questions, because I'm just trying to understand the implications of the rule that you want us to reach on this record where we're not really sure what's going on. Is your argument actually confined to the content of the school's curriculum? I mean, I appreciate that you say we're in the public school, this is a uniquely coercive environment, but what if we have a teacher who is gay and has a photo of a wedding on her desk? Is a parent able, or could they opt out of having their student be in that classroom?
Well, we think no, because the student, the student may claim a burden, but on the question of the student doesn't have the right to tell a teacher what to say. The teacher has speech rights that would.
But I guess I don't understand that, given your argument. I mean, so example one, we have a gay teacher in the classroom, and they have a wedding photo on their desk, and the children are exposed then to the same kinds of picture that you say is in the book that you don't want children to be exposed to. What about the parent, the teacher showing pictures from the wedding, or the teacher goes off to get married and comes back and talks about their spouse? Do we have opt-out provisions for children in that situation?
Again, we think the same rules would apply, and if you were in a system—
The same rules would apply. So this is not just about books. This is about exposure to people of different sexual orientations, and the objection, the sincerely held objection that children shouldn't be exposed to this?
Again, our clients are not raising those, and we know that these kinds of objections aren't happening. Here, the board is imposing indoctrination on children.
What if a student
beliefs.
group puts up "Love is Love" posters around the school featuring same-sex couples or trans youth? Do parents have to have notice of this and the ability to opt their children out of going into the parts of the school where these posters are?
Again, we don't think that any child has the right to dictate what the school does or what other students say.
No, they're not
say
dictating.
on
They just want an
campus.
opt-out. They don't want their children walking
We think they
in
would
the...
lose on that, in that situation.
Why? What about your principle does not also mean that if we have a section of the school with "Love is Love" posters and, children who have to go through there, what about your principle says that a religious parent shouldn't be able to say, "I don't want my kid walking in that part of the school"?
Well, they would lose because the strict scrutiny analysis would favor the board in that situation, because it would be impossible for the board to satisfy every student's needs about what's on the board. Now, if you're in a situation
I'm sorry, it would be impossible for them to actually implement an opt-out in that situation?
That's right. So if the request, for example, is so broad, like it was in Yoder, that the only option is for the students to be removed from the school entirely, that would be then the least restrictive means available. And so under normal strict scrutiny analysis, these things
Can I
would
give you
sort out
one
in
more?
favor of
What
the
about a
schools.
trans student in the classroom? There's a student who's in the class. Must the teacher notify the parents of the student's existence and give them an opt-out to not be in the same classroom with this child?
No, and we've never said that there's an independent right to be noted for schools to anticipate what parents might object to, but when parents know something, there could be a sincere religious burden.
Yes, a
But
parent
again,
knows. The child comes home and says, there is a transgender child in my classroom, and I know what you've taught me in terms of religious teachings. I object to that. Parent knows. Can a parent insist that the school allow the child to sit
Again, we think the
out?
parents would lose in that context.
All right, let me ask you one other set of questions about coercion, because Justice Kavanaugh points out that the test is burden. I had understood that the way in which this court analyzed burden in these kinds of cases is to look to coercion. So they really aren't a separate thing. And I guess what I'm really puzzling over is that it seems to me that coercion in this context is actually operating at two different levels, and that we have to kind of really focus on that in order to understand what's happening. One is to the students in the classroom, the coercion of being forced to be exposed to these kinds of materials or these kinds of things, or can they opt out? But I think there's another coercion, and you've touched on it a little bit, and that is assuming that there's no opt-out in this environment. Are students being coerced into being in that school at all? And I think those two different ways are really, really important. I mean, as I read our cases, we could have set up a constitutional framework in which all students are required to attend public school. They have to go to public school. And I think in that situation, you would have a pretty strong argument that it burdens a parent's religious exercise if the public school teaches children things that contradict the parent's religious beliefs. Here I am, I'm a religious parent, I have to put my kid in this school, and when my kid goes there, he's learning all sorts of things that I'm saying against my religious belief. I get that. But what do we do about the world that we're actually in, which is where Pierce says that the parent can choose to put their kid elsewhere, that you don't have to send your kid to public school? In that situation, I guess I'm struggling to see how it burdens a parent's religious exercise if the school teaches something that the parent disagrees with. You have a choice. You don't have to send your kid to that school. You can put them in another situation. You can homeschool them. How is it a burden on the parent if they have the option to send their kid elsewhere?
Well, Your Honor, the world we live in this case is that most parents don't have that option. They have two working parents. They can't afford to send a private school.
Absolutely.
And that's the reality for our parents.
I understand, but in so many other constitutional doctrines, we don't focus on whether people actually can afford to protect their rights.
Well, here they're forced to pay for the public
No, I
schooling.
understand, but usually we set aside and we say, but you still have the right to get an attorney in a civil case, even if you can't afford it, right? So we don't focus on whether or not they can actually do it. They have an option. And what I guess I'm worried about is a world in which, when there is an option to send your kids somewhere else, it seems to me that these parents would be dictating what this school does in the way that you say our cases say they can't do, right?
In Coercion versus Fulton, this court never required coercion. The parents were already paying tuition to go to the school. In all those cases, Lukumi, the schools didn't really need tires. They weren't being coerced to do anything. This court has always, since Sherbert, Adele Sherbert, Thomas, they weren't being coerced to do anything. They just were being pressured to violate their religious beliefs in order to access a benefit that's much less valuable than education.
Thank you, counsel.